Hello everyone. Today I'm going to explain some 50 legal maxims which do come in exams like RJS. You got 2-3 questions, and in Haryana Judiciary also, in Delhi lower and higher judiciary also. So legal maxims are very much important also to take care of. And today I'm going to explain some legal maxims related to CPC, and there are 50 in number right now as the PDF and the photographs is you can see on the screen. Number one is let's start. Acri incumbent honest probandi. The burden of proof lies on the plaintiff to state the facts, as we all know the pleadings chapter in CPC. So Order 6 Rule 2 provides for the same. Second is res judicata. All knows like a matter already judged cannot be litigated again. Section 11. Third is audi ultram partem, and that is here the other side. No one should be condemned unheard. Audi ultram partem, that's Order 9 and Order 5. That's fourth is obi just abi remedium. Now before proceeding further, let me explain like audi ultram partem is very much important in like 313 CRPC also, and in constitution also, and along with the principle of natural justice, like we have to listen the other side. Suppose there is a timeline provided, you have to file the written statement or pleadings in so and so period, and you are unable, or because of some reason you have not filed the same. So the court provides you the timeline again and in an extended period, like in which you can file the pleadings or any application again. So, and you have to explain the reason. Sufficient reason should be explained, and that's what audi ultram partem says. Fourth is ubi just remedium. Where there is a right, there is a remedy. Fifth is res subjudice. Again, section 10, matter pending decision cannot be tried again. Sixth is nemo debet vis vexuri pro una ad idem causa. No one shall be vexed twice for the same cause. Section 11. Again, section 300 CRPC also provides the same in case of you cannot be convicted or acquitted for the same cause of action. Seventh is interest republicae ut sit finis litium. It is interest of the state that there should be an end to litigation. Section 11. And to curb the multiple proceedings on the same cause of action. Eighth is ex terpi causa non aurita actio. No action arises from an immoral cause. Ninth is nemo judex in causa sua. No one should be a judge in his own cause. That's the principle of natural justice. Of course, you cannot benefit by your own, and you cannot decide also in your favor. Delegators, like in CRPC also, you can transfer the proceedings also, or whenever you have any good interest or beneficial interest, so you can get the transfer done also. Eighth is ex terpi causa non aurita actio. No action arises from any moral cause. 10th is ninth I already explained. 10th is delegatus non potest delegare. A delegated legislation also cannot be further delegated. Order 26 CPC also provides the same, like we have referred, like courts have referred the matter to the commission, so that act cannot be further delegated. 11th is que prior est tempo posture est jure. He who's earlier in time is stronger in law. Order 21, like you have to file the execution proceedings within the time. You have to be really vigilant also of your rights when to file the suit or the appeal. Be guarded against the timeline provided in the appeals and limitation law and CPC also, right? 12th is lex non cogit ad impossibilia. The law does not compel the impossible. Also, section 5 limitation act also does deal with it, which is impossible. Law cannot compel that to be done. Like when the court is closed, you cannot be compelled, yeah, to come and file your pleading or your application. 13th is actus curiae neminem gravabit. An act of court shall prejudice no one. Inherent powers under section 151 and section 482 CRPC. 14th is suppressio veri expressio falsi. Suppression of truth is equivalent to expression of falsehood. Like in contract also, this is the basic principle. You have to explain all the facts. You need not hide what is false, and you have to state the truth, because it will affect the judgment of the judge also who is hearing the case. Like you have to explain all the facts to the court to get a fair judgment, and it will have a positive impression on the judge also, like if you do abide by. And in contract also we do see this principle. 15th is res judicata pro veritate occupita. A decision once made is accepted as true, section 11 CPC. 16th is dura lex sed lex. The law is harsh, but it is the law. Of course, ignorance of law is no excuse. We did in CPC and CRPC. 18th is 17th we have to go by. False is in uno, false is in omnibus. False in one thing, false in everything, right? But this principle does not apply to Indian proceedings. So that's for evidence consideration. And 18th is de minimis non curate lax. The law does not concern itself with trifles. Of course, section 95 also CRPC explains. 19th is nullus commodum capior potest de injuria sua propria. No one can gain advantage from his own wrong. 20th is vigilantibus est non dormentibus jura subvenient. The law helps those who are vigilant, not those who sleep. That's a limitation context also. You have to file all the things and applications within time. 21st is omnia praesumitur right esse acta. All things are presumed to be done rightly. 22nd, fiat justitia ruat caelum. Let justice be done though the heavens fall. Inherent parts again. So the basic function what the courts do is dispensation of justice, and justice is the only criteria what the courts are meant for. 23rd is expressio unius est exclusio ulterius. The express mention of one thing excludes all others. 24th, verba generalia restinguntur ad habilitatum re. General words are to be restrained to the fitness of the matter. That's a matter of interpretation. 25th is injuria non excusat injurium. One wrong does not justify another. That's a procedural abuse. 26th is in pari delicto quotio est conditio defendatis. In equal fault means when the two parties are at fault, one has filed an action and the defendant asserts, like the plaintiff was also in pari delicto condition, so its defendant gets advantage over it. 27th is nociter a sources. A word is known by the company it keeps. That's interpretation of pleadings. 28th, utris majus valiat quam paruit. It is better for a thing to have effect than to be void. 29th, salus populi est suprema lex. The welfare of the people is the supreme law, as we see in public interest litigation. Also, it's a principle of evidence law also. Salus populi est suprema lex, like welfare of the people is only the supreme consideration, supreme law. I will see like various judicial interpretations made by the judiciary. Next is 30th, inclusio unius est exclusio ulterius. Inclusion of one is the exclusion of another. 31st, acquitus sequitur legem. Equity follows the law, CPC. 32nd, equity acts in personam. Equity acts on the personam. 33rd, he who seeks equity must do equity. A claimant must act fairly. He must come to the court with clean hands. 34th, specifically applicable in injunctions also, and in CPC if you are claiming and you should not be a defaulting party. 34th is he who comes to equity must come with clean hands, like balance of convenience and prima facie case, etc. 35th is equity looks on those as done which ought to be done. Equity treats the subject matter as if it's already done. 36th is judex est lex loquens. A judge is the law speaking. Whatever judge states, that's law. Judges do interpret the laws also. That's a judicial function to do. 37th is non obstante, notwithstanding. 38th is ratio descendi. The reason or rationale for the decision. 39th is obiter dicta. Statements made in reference. That's not the judgment already explained, but that's like only some statements made while passing the judgment, that's obiter dicta. And 40th is the stare decisis, to stand by the decisions and not to disturb the settled matters. That's binding precedent and applicable on the lower judiciary, trial courts and high courts also. 41st is caveat emptor, let the buyer beware. 42nd is actus de nemini facet injurium, an act of God injures no one. Obviously, force majeure contracts, suppose you have entered into an agreement and there is some default done because of the act of God, or some impossibility, or some war is started. Next is volenti non fit injuria, to one who consents no harm is done. 44th is damnum si injuria, it means damage without legal injury. 45th is injuria sin damno, legal injury without damage, that's actionable. 44th and 45th clearly explains, like if your legal right is violated, then you can maintain and file an action, but if no damage is done or damage is done, that doesn't clearly meant to be applicable here. Only the legal injury is to be seen, damage is done or not done, that's irrelevant. 46 is lex fori, that's law of the forum. 47th is lex loci delicti, law of the place where the tort was committed, jurisdiction in civil wrongs again. 48th is lex talionis, that's law of retaliation, principle of equal treatment, eye for eye and concept. 49th is amicus curiae, friend of the court, again used in PILs, public interest litigations. They do assist the court in as a friendly officer. 50th is mutatis mutandis, with the necessary changes having been made. Mutatis mutandis means a thing is done with alterations but not changing the basic core of that thing. That's mutatis mutandis. You apply the same principles but without changing the core if different stated facts, interpretation and application of rules, right?